Out there, legal warriors, in an ode to Chummy Emu, presenting to the courtroom, doing nothing. If you've done nothing in your criminal case, you're in big problems. Stay tuned, find out what you do need to do. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Linwood, Washington. I've been defending people charged with crimes for more than 20 years. I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. I'm just going to jump right into it. You know, I started with another an internet sensation. I'm not Chubby Emu, who talks about diagnosing problems and solutions to cases. And he starts oftentimes presenting to the emergency room with such and such a symptom. Well, a case is sort of like that. We present a case to the courtroom, we present a case to the prosecutor, and it's really important that if someone you care about, or if it's you that's charged with the crime, that person charged with the crime does something to help their case. And in this video, I'm going to sort of diagnose why that's important, why it works that way, and to give sort of some more incentive to do some things to help improve your chances of getting a great result in your criminal case. So, what do I mean by that? Well, let's think about it from the prosecutor's point of view. Let's say that you've got two identical cases that you're prosecuting. They're both assault charges, and each one doesn't have a record, and you're totally buried in cases. The system is overwhelmed right now. And again, I was a prosecutor for 7 years plus, so I know a little bit of what this is like. So I have two identical cases. One defendant, that defendant has done some anger management classes, might have done some domestic violence classes, has done a victim's panel, has done something. The other defendant has done nothing. Equal looking cases. So which one am I more likely to want to lighten my own load with by giving a more lenient offer that they're likely to take and take one more case off of my plate as the prosecutor? Which one? Well, if this hypothetical is correct, probably the one that's already done something. And why? Because it makes me as the prosecutor feel like I'm part of the solution. If I'm the prosecutor, it is not my job to let people go. It's my job to respond to cases in some way. And I know I can't take them all to trial. I can only take a small percentage to trial, and taking a case to trial is hard work. You know, my weekend's blown, my time with my family's blown, all those things. And so I want to try to find a way to respond to cases if I'm a prosecutor, while also doing justice and recognizing what a broken system I work in, and justice can be abbreviated based upon the realities of me doing prosecution. So that is why a prosecutor may care about classes and things that a client or defendant has done. My client, defendant to them. So when doesn't this apply? Well, major felonies, the prosecutors don't have a lot of leeway. They are typically negotiating cases based upon evidentiary reasons only. So a murder, a rape, massive felonies, firearm stuff, they're probably not really paying too much attention to classes. They don't have a lot of discretion, right? They've got to negotiate more on the fact pattern. Well, Lance, what about misdemeanors? Doesn't the fact pattern matter there also? Yes, it does. That informs the negotiation. But in reality is, a criminal prosecutor at the misdemeanor level might have hundreds of cases. And so it's smart if you're on the defense side to not dig into every little fact, because they don't have the chance really to do that until it gets set for a trial. They can't do that for all their cases. And once it gets set for a trial, in many cases, negotiations are over, right? Now you're making them work, and they're more going for the throat at this point, okay? So we want to take every chance we can to try to end up in a situation where the best possible offer, hopefully the case being dismissed even, can be made to the client without risking what the 6 people on the jury say. 12 for felony, but 6. Because people are mad, right? People want to get even with people. People think people are guilty because they're charged with crimes. There's not a big lobby for people accused of crimes, right? Everything is, you did wrong, you did bad. So you want to avoid being in that situation. It costs more money, it's more stressful, and it usually leads to a bad result. Even someone who's innocent can be convicted, and it happens all the time. So, what are some objections that we hear from clients about doing classes? And there's several. The most common one is, well, it's an admission of guilt. I feel like I'm admitting guilt if I do this. You're not admitting guilt. It's not usable against you in a trial. They can't say, he did anger management, so he must have an anger problem. Evidence rules exclude that, okay? It's not that you need to do it. It's that your case needs it done. And hopefully you're going to benefit from it as well, right? Hopefully you'll benefit from it, but the case needs it, not you. So it's not a personal thing. It's like, hey, I'm in a bad situation. I'm going to take my medicine. If my doctor says I need to take certain medicine to cure my cancer, it may not be fair, but I'm taking my medicine because it's going to help me, right? It might make me sick, but it might also help cure me. Same way with doing classes. Think about it that way. Another thing would be, I didn't do anything I shouldn't have to, right? True, you shouldn't have to, but back to the metaphor, there's lots of things we shouldn't have to do, right? We shouldn't have to pay taxes, but if we don't, things are going to be worse for us. So let's try to make things better for us for doing things that will help us, right? And in many cases, they can't help us. Lance, give me some examples. What are some examples of certain types of cases where certain types of classes might help? Well, if you got a DUI, the obvious one would be doing an alcohol and drug evaluation, following up with treatment. So in that case, we'd want to make sure that the results only go to your attorney because you're doing it voluntarily. And if you do it earlier in the case, you certainly show you're more responsible and you're a better risk for a prosecutor to make a decision to be more lenient with you than someone who hasn't put themselves in that situation. What if it's a domestic violence case? Well, domestic violence, moral recognition therapy, DVMT, 6 months of classes, that's sort of the gold standard nowadays, right, to do. And it's very inexpensive, might be $200 to $400. If it's not that serious a case, maybe anger management. Let's say it's straight assault. Maybe you do an 8-hour anger management class, a 16-hour anger management class. Let's say you're accused of disciplining a child too severely. You have an assault of a child or something. Well, parenting classes maybe to figure out how to deal with these stressful situations more. I mean, kids don't come with a manual, right? We should never do anything against the law to children, but if something happens, maybe we can get an education so it doesn't happen again. Let's say it's a theft case where, maybe depression has led to multiple thefts. Well, let's get some psychotherapy. Let's do some counseling so we can be part of the solution for the prosecutor, and the prosecutor can feel part of the solution and do something different than just put you in jail. So those are things that we want to consider doing. And so what are the pitfalls? Well, doing the wrong treatment. You searching the internet and deciding what you want to do on your own. You need to talk to your attorney. Because as I always say, law is local. What Issaquah Muni typically expects for treatment in a case may be totally different than what Linwood Municipal wants for a case. And I know it's different than what the county might want for a case. Your attorney may know that if they're experienced, so you don't waste your time and money doing the wrong things. Additionally, you generally only want any treatment you do to go to your attorney so your attorney can use it in a strategic manner. In a strategic manner. We don't want stuff going to the court unless there's a reason for it. So usually if we're doing this type of classes and treatment stuff, it's prior to the case being resolved is what I'm talking about. Post-resolution, you may be ordered for it to go to the court. And then another thing we want to avoid is just not doing the wrong treatment is having an attorney who tells you to do nothing. I don't like that, okay? An attorney tells you to do nothing, and maybe they just don't want to take such an advanced approach. They think that it won't help, maybe. I don't know, but I would really push my attorney to find me something to do because it can't hurt your case to do something. And sometimes that can be the difference. The fact you did something and the 3 defendants on the same calendar next to you didn't do anything means that you're more likely to get that offer with everything else being equal. I think expenses, we have to worry about that. If it's too expensive what the attorney is asking you to do, ask them if there's an alternative. Sometimes we can do some mixing and matching, right? Sometimes we're going to send you to the place that's convenient for us, and we don't live your life. We don't know for sure what it is you can afford, right? So don't be afraid to speak up, because maybe we can find something cheaper or something that's close enough. That's not the gold standard, but maybe it's silver or bronze to help your case, but you can actually pull off. Don't be afraid to say, hey, can you find me something that works with my work schedule or my childcare schedule, right? We can look around. We know more than you do about it, and you can be part of the solution too once we sort of know what you need to do. So it's important. It's important that we take some affirmative steps so the prosecutor can feel they're part of the solution, so they're more able to hear our side of the story. That's my opinion. It's worked for my law firm for 20 plus years, and hopefully it will work for you or your loved one if you're in this situation. So if you find this useful, please like and please subscribe. More people will get to see it. And more importantly, if you got a legal problem in Washington State, a criminal matter, feel free to reach out to us. We'll listen to what happened. We'll identify a way forward, and we will be there for you. Thank you.